whether the Dolly Secretary or the regional directors have jurisdiction when the total amount of monetary claims exceeds 5,000. Letter C. The expanded jurisdiction of the Dolly is not affected whether the case is the result of regular inspection under Article 128B or it originates from a complaint under either Article 129 or Article 224. The exercise of the expanded jurisdiction by the Dolly under Article 128B as amended by RA number 7730 is not at all affected by the manner it has taken cognizance of the issues brought and raised before it. It is thus inconsequential whether the issues emanated in the course of regular inspections undertaken by the Dolly under Article 128B or originated from a complaint initiated either under Article 129 or Article 224. The NPAC resolution in the 2012 case of People's Broadcasting Service, which modified its earlier May 8, 2009 decision, clarified this point. Thus, there is a view that despite Article 128B of the Labor Code as amended by RA number 7730, there is still a threshold amount set by Articles 129 and 224 of the Labor Code when money claims are involved. Example, that if it is for 5,000 pesos and below, the jurisdiction is with the RD or the Regional Director of the Dolly under Article 129, and if the amount involved exceeds 5,000, jurisdiction is with the Labor Arbiter under Article 224. The VU states that despite the wording of Article 128, this would only apply in the course of regular inspections undertaken by the Dolly, is differentiated from cases under Articles 129 and 224, which originate from complaints. There are several cases, however, where the court has ruled that Article 128 has been amended to expand the powers of the Dolly Secretary and his duly authorized representatives by RA 7730. In these cases, the court resolved that the Dolly had the jurisdiction despite the amount of the money claims involved. Furthermore, in these cases, the inspection held by the Dolly Regional Director was prompted specifically by a complaint. Therefore, the initiation of a case through a complaint does not divest the Dolly Secretary, is duly authorized representative of jurisdiction under Article 128. B. For more extensive discussion on this topic of conflict of jurisdiction between labor arbiters and Dolly Regional Directors, please read the notes and comments on Article 128 of the Labor Code found in Volume 1 of this 3-volume series on the Labor Code by the author. 3.2. Whether the Dolly Secretary or the Regional Directors have the power to determine the existence of employer-employee relationship to the exclusion of the labor arbiters of the NLRC. A. Existence of employer-employee relationship is essential to validly vest jurisdiction of the Dolly Regional Director. The existence of the employer-employee relationship initiation of the action under Article 128B is an essential requisite. Based on this requisite, the Supreme Court in the case of EJR Gulfs Corporation versus CA disagreed with the contention of petitioner that the labor arbiter and not the Dolly Regional Director has jurisdiction over this case. It held that considering that there still exists an employer-employee relationship between petitioner and private respondents and that the case involves violation of the labor standard provisions of the Labor Code, the Dolly Regional Director has jurisdiction to hear and decide the instant case in conformity with Article 128B. Notwithstanding the provisions of Article 129 and 224 of this code to the contrary, and in cases where the relationship of employer-employee still exists, the Secretary of Labor and Employment or his duly authorized representatives shall have the power to issue compliance orders to give effect to the labor standards provisions of this code and other legislation based on the findings of labor. Assistance. It was further emphasized in Regional Security and Protective Services INC versus Honorable Maraan from what is material to consider is that at the time of the filing of the complaints or claims for payment of monetary benefits with the Dole Regional Office, the complaints were still employees of a petitioner company. Here, petitioners' reliance on Section 3, Rule 2 of the Rules of the Disposition of Labor Standards cases in the regional offices was held to be inappropriate. While it is true that the said provision states that where the employer-employee relations have been severed, complaints or claims for payment of monetary benefits fall within the exclusive and original jurisdiction of labor arbiters, such is not the case. However, in the present petition, to emphasize on the time private respondents instituted by filing a complaint with the Dole Regional Office, they were still employees of petitioners. Well settled is the rule that jurisdiction of a court over the subject matter of an action is determined by the allegations of the complaint. Of the complaint at the time of its filing, irrespective of whether or not the plaintiff is entitled to recover upon all or some of the claims asserted therein. In Catholic Vicariate, Baguio City versus Honorable Santo Tomas, the petitioner questioned the validity of the exercise of jurisdiction by the Dole Secretary under Article 128B. The Supreme Court, however, upheld the jurisdiction of the Dole Secretary because the following limitations that will divest her of jurisdiction would absolve her in: first, the employer contests the findings of the labor regulations officer and raises issues which cannot be resolved without considering evidentiary matters that are not verifiable in the normal course of inspection, and second, the employer-employee relationship no longer exists. B. Labor arbiters of jurisdiction if employment relationship no longer exists at the time of the initiation of the action under Article 128B. If at the time of the initiation of the action under Article 128B, the employer-employee relationship had already ceased to exist, it is not the Dole Regional Director but the labor arbiter who has jurisdiction over the same, as emphasized in the case of Batong Buhay Gold Mines versus Secretary de la Serna. Accordingly, if on the face of the complaint it can be ascertained that employer-employee relationship no longer exists, the case whether or not accompanied by an allegation of illegal dismissal, should immediately be endorsed by the regional director to the appropriate branch by NLRC. Under the second of the three requisites for the valid exercise of the visitorial and enforcement power under Article 128B, it is essential that the findings in question. Under the second of the three requisites for the valid exercise of the visitorial and enforcement power under Article 128B, it is essential that the findings in question were made in the course of inspection by the labor inspectors. Corollary to the second requisite is the third requirement, and the affected employees should not have initiated yet any claim or complaint on the violation of the labor standards provisions of the law with either the Dole Regional Director and under Article 129 or the labor arbiter under Article 224. B. Because once the complaint has already been taken cognizance of the Dole Regional Director or by the labor arbiter under Article 224, jurisdiction attaches thereto and will not be lost as a result of the findings made as of the inspection with the labor inspectors. Jurisdiction attaches thereto. Authorship of the regional directors to determine the existence of employer-employee relationship to the exclusion of labor. Because of the clause in case where the relationship of employer-employee relationship still exists, Article 128B, an issue has been raised on whether it is within the power of the Dole Secretary or his duly authorized representative, the regional director, to make a determination on the existence of employer-employee relationship in cases falling under Article 128B. Of relevance is People's Broadcasting Service, in which the Supreme Court Second Division has first issued a decision on May 9, 2009 and later en banc resolution. The motion for clarification promulgated March 6, 2012, and De Leon Vezan against petitioner People's Broadcasting Service and Bombo Radio Philippines for illegal deduction and payment of service incentive, leave, 13-month pay, premium pay for holiday and rest day, and illegal diminution of benefits, delayed payment wages, and non-coverage of SSS pag-ibig and PhilHealth for the Dole Regional Office Number 7, Cebu City, after the conduct of summary investigations in the party submitted the opposition papers. The Dole Secretary, Dole Regional Director, found that petitioner and was entitled to respond to claims petitioners. Under the director's order but failed, the acting Dole Secretary dismissed petitioners. The casual surety bond matter for the CA who petitioner claimed that it had been denied due process. It was held supported due process it had been given the opportunity to be heard and that the Dole Secretary had jurisdiction. So the jurisdictional limitation posed the labor code on the power the Dole Secretary and the code had been repealed by RA 77 in its May 8, 2009 decision. The Supreme Court found that there was no employee in petitioner by arbiters found that it was held that while the Dole may make a determination of the existence of employee relationship be coextensive with the visitorial and enforcement power provided in Article 128B. In over 770, the NLRC to be the primary agency in determining the existence of an employer-employee relationship. This was the interpretation of the court of the clause in case where the relationship of employer-employee still exists. Article 128B, from its decision, Public Attorney's Office or PAO filed a motion for clarification of decision with leave of court. The POW sought to clarify as to whether the visitorial and enforcement power of the Torah be not considered as coextensive with the power to determine the existence of an employer-employee relationship. In its comment on the Dolly sought clarification as well as to the extent of its visitorial and enforcement power as a second motion for reconsideration granting said motion and reinstating the petition. It is apparent that there is a need to delineate the jurisdiction of the Dolly Secretary vis-a-vis that of the NLRC. In effect, the prior May 8, 2009 decision of the Supreme Court in the present case accepts the fact that the Dolly and determination of whether or not an employer-employee relationship exists, limitation upon the power of the Dolly, that is, the determination of the existence of an employer-employee relationship, extending with the visitorial and enforcement power of the Dolly. Even in conceding the power of the Dolly to determine the existence of an employer-employee relationship, the court held that the determination of the existence of an employer-employee relationship is within the power of the NLRC. Still, NLRC, that the finding by the Dolly is merely preliminary. Thus, in the March 6, 2020 in Bank Resolution, the Supreme Court declared that the exclusion must be revisited. This revisitation elicited the following conclusion, which should now be the controlling dictum on this part of law. First, there is lack of limitation in the law of the power of the Dolly to existence of an employer-employee relationship. Second, the Dolly, in so determining the existence of the employer-employee relationship, can use the same set of guidelines known as the fourfold test of employment relationship. Number 3, the Dolly's determination of the existence of the employer-employee relationship should be respected in order not to render nugatory the existence of its visitorial and enforcement power. Number 4, the Dolly's finding of existence of employer-employee relationship is to the exclusion of the NLRC. Number 5, the Dolly's determination of the existence of employer-employee relationship is subject to judicial review, not review by the NLRC. Recapitulation of the rule. To recapitulate, if a complaint is brought before the Dolly to give effect to the labor standards provisions of the labor code or other labor legislation, and there is a finding by the Dolly that there is an existing employer-employee relationship, the Dolly exercises jurisdiction to the exclusion of the NLRC. If the Dolly finds that there is no employer-employee relationship, the jurisdiction is properly with the NLRC. If a complaint is filed with the Dolly and it is accompanied by a claim for reinstatement, the jurisdiction is properly with the labor arbiter under Article 217, Paragraph 3 of the Labor Code, which provides that the labor arbiter has original and exclusive jurisdiction over those cases involving wages, rates of pay, hours of work, and other terms and conditions of employment. If accompanied by a claim for reinstatement, if a complaint is filed with the NLRC, there is still an existing employer-employee relationship. Jurisdiction is properly with the Dolly. The findings of the Dolly, however, may still be questioned through the petition for church. Article 65 of the Rules of Law. The foregoing ruling in People's Broadcasting has been affirmed and iterated in the 2016 case of South Cotabato Communications Corporations versus Honorable Patricio Santo Tomas. Thus, like the NLRC, the Dolly has the authority to rule on the existence of an employer-employee relationship between the parties, considering that the existence of an employer-employee relationship is a condition sine qua non for the exercise of its visitorial power. Nevertheless, must be emphasized that without an employer-employee relationship, or if one has already been terminated, the Secretary of Labor is without jurisdiction to determine if violations of labor standards provision had in fact been committed and to direct employers to comply with their alleged violations of labor standards. 3.3. Whether the labor arbiters has jurisdiction over the contested cases mentioned in the exception clause in Article 128b. Labor arbiters have jurisdiction over contested cases under the exception clause in Article 128b. Requisites. The exception clause in Article 128b, as amended by RA number 7730, states that the Secretary or his duly authorized representatives shall issue writs of execution to the appropriate authority for the enforcement of their orders, except in cases where the employer contests the findings of the labor employment and enforcement officer and raises issues supported by documentary proofs which were not considered in the course of inspection. In interpreting the aforequoted provision of the exception clause, three elements must concur to divest the regional director or his representatives of jurisdiction under to wit, that the employer contests the findings of the labor regulations officer and raises issues thereon. Letter B, that in order to resolve such issues, there is a need to examine evidentiary matters, and letter C, that such matters are not verifiable in the normal course of inspection. Resultantly, if the said elements are present and therefore the labor standard case is covered by said exception clause, then the RD, regional director, will have to endorse the case to the appropriate labor arbiters of the arbitration branch of the NLRC as held in Ex Bataan Veteran Security Agency ANC versus the Secretary of Labor Laguesma. Meteoro versus Creative Virtues INC best illustrates the implication of the exception clause. Here it was held that the CA aptly applied the exception clause because at the earliest opportunity, respondent company registered its objection to the findings of the labor inspector on the ground that there was no employer-employee relationship within petitioners and respondent company. The labor inspector in fact noted in its report that respondent alleged that petitioners were contractual workers and were independent and talented workers without control or supervision, and also supplied with tools and apparatus pertaining to the job. In its position, respondent again insisted that petitioners were not its employees. It then questioned the regional directors of jurisdiction to entertain the matter before it primarily become because of the absence of an employer-employee relationship. Finally, it raised the same arguments because before the Holy Secretary and the appellate court, it is therefore clear that respondent contested and continues to contest the findings and conclusions of the labor inspector to resolve the issue raised by respondent, that is, existence of an employer-employee relationship. There is need to examine evidentiary matters. 3.4. Whether the factual findings of the Holy Secretary, the regional directors are binding on labor arbiters and the NLRC under the doctrine of res judicata. The issue of whether the labor arbiters and the NLRC are bound by the factual findings of the Holy Secretary and the regional directors made in the exercise of their visitorial enforcement powers under Article 128 was raised in the 2012 case of Norquist Trading Corporation versus Buena Vista. This case for illegal suspension, illegal dismissal, unfair labor practice, and other monetary claims was filed with the labor arbiter. During its pendency for the labor arbiter, respondents filed a separate complaint before the Dole Regional Director under Article 128 Petitioner Norquist Trading and panaghiusa sa kauswagan multipurpose cooperative, where they saw the declaration of Pasaka, the cooperative which complied respondents to petitioner Norquist Trading as a labor-only contractor. The labor arbiter dismissed the said complaint, leading respondents to file an appeal with the NLRC. During the pendency of the appeal before the NLRC, the Dole Regional Director issued an order to Kera Pasaka, a labor-only contractor, and holding it and Norquist Trading Solidarity liable for all the claims of respondents. Respondents filed a manifestation with the NLRC to inform it of the issuance of said order by the Dole Regional Director. The NLRC, however, disregarded said finding of the Dole Regional Director, which was later on affirmed by the Dole Secretary, the CA, and the Supreme Court, whose decision thereon had later attained finality. The CA had declared that the act of the Dole NLRC's findings of the Dole Regional Director and the Dole Secretary abuse of discretion. The Supreme Court held that SAE committed an error in finding grave abuse of discretion on the part of the NLRC, but the latter's utter disregard of the findings of the Regional Director that Norquist Trading should be considered the employer of herein respondents. There is no doubt, therefore, that the findings of the Regional Director and NLRC Philippines are insufficient. Therefore, it was held that the finding of the Regional Director, which had been affirmed by the Undersecretary of Labor, by that the cooperative Canary Multipurpose Cooperative COMCO was engaged in labor only contracting should find the NRC in a case for illegal dismissal. Roman numeral number 15, jurisdiction of enforcement or annulment of compromise agreements. Legal basis. Article 233 embodies the following provisions on compromise agreements. 233. Compromise agreements. Any compromise settlement, including those involving labor standard laws, voluntarily agreed upon by the parties with the absence of the Bureau or the Regional Office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commission or any court shall not assume jurisdiction over issues involved therein, except in case of non-compliance thereof, or if there is a prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. Clear from the foregoing provision is that, albeit the compromise agreement may have been entered into by the parties before other labor agencies like the Bureau of Labor Relations or the Regional Office or under SENA, it is the labor arbiter who has jurisdiction to take cognizance of the following issues related thereto, to the exclusion of said agencies, to enforce compromise agreement in case of its non-compliance by any of the parties thereto, to nullify if there is a prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. Number 2. Provision in the NLRC rules. A similar provision is found in the 2011 NLRC Rules of Procedure, where the jurisdiction of the labor arbiters is recognized over the enforcement of compromise agreements when there is non-compliance therewith by any of the parties pursuant to Article 233. Number 3. Compromise agreements executed through SENA. Any agreement entered into by the parties to a case being heard through the single entry approach in the SENA should be voluntarily and faithfully complied with by them. In case of non-compliance by any of the parties, the agreement should be endorsed by the desk officer to the labor arbiter of the NLRC for enforcement. Number 4. compromise agreements executed before the NCMB. Although Article 233 refers only to compromise agreements entered into before the BLR and Dole Regional Director, the same rule vesting jurisdiction to labor arbiters over cases involving compromise agreements also applies to any other compromise settlements, including those involving labor standards laws voluntarily agreed upon by the parties with the assistance of the National Conciliation and Mediation Board and its regional branches. Thus, as provided in the rules to implement the Labor Code, the NLRC or any court cannot assume jurisdiction over issues involved therein except in case of non-compliance thereof or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion upon motion of any interested party. The labor arbiter in the region where the agreement was reached may issue a writ of execution requiring a sheriff from the commission or the courts to enforce the terms of the agreement. Roman numeral number 16, jurisdiction over enforcement decisions of voluntary arbitrators. Number 1. Decisions of voluntary arbitrators. Article 276 prescribes the procedure that voluntary arbitrators or panel of voluntary arbitrators should follow in adjudicating cases filed before them. Once a decision has been rendered in a case and subsequently becomes final and executory, it may be enforced through writ of execution issued by the voluntary arbitrator or panel of voluntary arbitrators who rendered it, addressed to and requiring certain public officers to execute the final decision, order, or award. Number 2, labor arbiters may issue the writ of execution in situations, however, where the voluntary arbitrator or the panel of voluntary arbitrators who render the decision is absent or incapacitated for any reason. Article 276 grants jurisdiction to any labor arbiter in the region where the winning party resides to take cognizance of a motion for the issuance of the writ of execution filed by such party and accordingly issue such a writ addressed to and requiring said public officers to execute the final decision, order, or award of the voluntary arbitrator or panel of voluntary arbitrators. For more extensive discussion on this topic, issuance of labor arbiter of the writ of execution to enforce decisions, orders, or award of voluntary arbitrators, please read notes and comments. Article 276 on the Labor Code. Roman numeral number 17. Jurisdiction over OFW cases. Labor arbiters have jurisdiction over all money claims of OFWs. A. Conferment of jurisdiction over money claims of migrant workers under RA number 8042. RA number 8042 conferred original exclusive jurisdiction upon labor arbiters to hear and decide all claims arising from employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages. To implement this law, the Dole Secretary and the Secretary of Foreign Affairs jointly issued on February 29, 1996 the Omnibus Rules and Regulations implementing the migrant workers and overseas Filipinos. The same provision in the law, the jurisdiction of the labor arbiters must replicate in Section 62 thereof provides that all unresolved money claims pending before the POEA as of July 15, 1995 shall be referred to the NLRC for disposition. However, it must be stressed that RA number 8042 is not a curative statute, hence it cannot affect the jurisdiction over cases filed prior to its effectivity. B. Latest amendment to RA number 8042 introduced by RA number 122. RA number 8042 is specifically Section 10 thereof, which conferred jurisdiction over all money claims of OFWs to labor arbiters, was amended lately by RA number 102. The jurisdictional authority of labor arbiters over these claims was completely reaffirmed. That is, Lex Loci Contractus Rule. Since employment contracts signed by OFWs are approved by the POEA and are entered into and perfected in the Philippines, the Lex Loci Contractus Rule governs said contracts. The Labor Code is implementing rules, regulations, and other laws affecting Lex Loci Contractus apply thereto. Therefore, should apply thereto. Number 2. Voluntary arbitrators and not labor arbiters have jurisdiction over money claims if there exists a CBA. A. The distinction lies when there is a CBA. In at least 2 recent 2012 decisions of the Supreme Court, the jurisdiction of labor arbiters over monetary claims of FWs was distinguished from that of the voluntary arbitrators. A panel of voluntary arbitrators to it, Ace Navigation Company Agency versus Fernandez, involving the disability claim of respondent, and Estate of Dulay versus Aboitiz Jepson Maritime Agency, Regional Charterers Agency, involving the claim for death benefits of petitioner. In summary, it was ruled in these cases that in case there is a CBA between the employer and the bargaining union to which the complaining FW belongs, the original and exclusive jurisdiction over its monetary claims belongs to the voluntary arbitrator or panel of voluntary arbitrators and not to the labor arbiters. Constitutional and legal basis. The basis of the rulings in Ace Navigation and Estate of Dulay are the following constitutional and legal provisions. Section 3, Article 13 of the Constitution, which states that the state shall promote the principle of shared responsibility between workers and employers in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. Articles 273, 274, and 275 of the Labor Code, Section 29, on dispute settlement procedures of the POEA, which governs the employment. Number 3, RW-related cases which the POEA and not the Labor Code arbiters as jurisdiction. Jurisdiction of the POEA. Under the 2 separate 26 revised POEA rules, land-based OFWs and seafarers, and the omnibus rules, the Philippine Overseas Employment Administration has original and exclusive jurisdiction to hear and decide all cases which are administrative in character involving or rising out of violations of recruitment rules and regulations, including refund or fees collected from the land-based OFWs and seafarers, and any violation of the conditions for the issuance of the license to recruit OFWs. Disciplinary action cases, land-based OFWs and seafarers, and principals or employers that are administrative in character, excluding money claims. B. Nature of POEA. Proceeding administrative, not criminal. The administrative determination of facts and the consequent imposition of the suspension or revocation of authority or license does not make the POEA proceeding criminal. It remains administrative in character. Cases not falling under the jurisdiction of the POEA. In summary, the following are the cases not falling under POEA's jurisdiction: money claims, cases of OFWs. The POEA had ceased to have any jurisdiction claims over claims arising of the employer relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages. The jurisdiction over these claims, was transferred to the labor arbiters of the NLRC by virtue of Section 10 of RA 8042 as amended. Number 2, quasi-dialect or tort cases. The POA has no jurisdiction over tort cases where the complaint alleges claims under the Civil Code and not under the Labor Code. Even labor arbiters and the NLRC have no jurisdiction over cases dealing over quasi-dialect or tort cases per Article 2176 of the Civil Code that have no unreasonable causal connection to any of the claims provided in the Labor Code, other labor statutes, or collective bargaining agreements. Quasi-dialect or tort cases are recognizable by the legal courts. Number 3, enforcement of foreign judgment. The POA, being an administrative body, perform adjudicatory or quasi-judicial functions, has no jurisdiction to hear and decide a claim for enforcement of a foreign judgment. Such claim must be brought before the regular courts. Number 4, local employment. The POA has no jurisdiction where the cause of action rests upon the latest local employment contract and not the overseas contract. The jurisdiction thereover lies with the labor arbiters of the NLRC. So, for more comprehensive discussion, please refer on Article 35 of the Labor Code found in Volume 1 of this 3-volume series of the Labor Code by the author. So we'll stop there and we'll continue. The next is Roman numeral number 18. Other issues over which labor arbiters have jurisdiction. Right, already at page 86.